Welcome, everyone, and thank you for joining us for this business succession planning webinar. My name is Dermot Reiter. I'm a senior financial advisor here at Apt Wealth Partners. And joining me again today is Leon McPaul, who is the head of estate planning at Apt Wealth Legal Services. Leon has extensive experience in helping families structure their succession plans, navigate an array of complex legal issues, and ensure their intentions are clearly documented. And he's widely respected across the industry for his thorough and yet his practical approach, and we're very fortunate to have him share his insights with us today. So welcome, Leon.
Appreciate it, Dermot. Thank you for having me.
Very good. Well, we've got a bit of a full agenda today, but we're going to explore a framework for business succession decision making. We're going to look at the key business succession strategies for business owners to consider. We're going to look at how to plan for incapacity and effectively navigate complex family dynamics. We'll then walk through the key documents that you have to have in place before sharing our top tips and taking a few questions at the end. So feel free to put some questions in the chat as we go along. But to start with, I think framing the business succession decision-making process, we need to have a framework, and we can use this as a bit of a roadmap for creating a concrete and yet an actionable business succession plan. So the foundation of any effective plan is to define what an ideal outcome looks like. Because if we define success only as achieving a price, we might get one answer. But if we include other aspects like legacy, family harmony, and lifestyle choices, we may choose a very different path. So once the clear objectives are set, the next step is to choose the preferred succession path. And broadly speaking, business owners have three main options at their disposal. You can keep it in the family, you can hand it to management or key staff, or you can sell to an external buyer. So we'll explore the merits of each option and the different tax governance and financial implications of each. We then need to set a time frame for a transition plan. So owners often underestimate how long it can take to transition a business. Your timeline determines the training that you might need for successors, how much you can de-risk the business, whether you phase out or make a clean exit, and how you manage your stakeholder expectations along the way. It's then crucial to align your business ownership structure, as this can dramatically impact the tax outcome and the funding strategy. And this is where the technical expertise of the likes of Leon and myself becomes crucial. Because a good succession plan is not just who gets what, but who pays, when they pay, from where, and what is the after-tax result. So we need to think about things holistically and comprehensively, and we'll walk through how we do that. And then finally, we really need to have a strong governance framework supported by well-crafted documents that are communicated effectively to those that are affected. Because we know that the plan that works is typically the plan that's written down, understood by the people that it affects, and kept up to date as life inevitably changes. So I thought we'd start with just understanding what success looks like. And this is going to be different for every business owner. But for some of you, success really is about maximizing the sale price and walking away clean. But for others, it's more about legacy, keeping the business in the family, looking after loyal staff, and continuing what you've built. But often it's a mix of both. So you need to honestly ask yourself questions such as, how important is maximizing the potential sale proceeds versus the trade-off of ensuring the continuity of the business? Now, most business owners land somewhere on a spectrum in answering this question, but where you land matters enormously. And we can help sort of unpack those issues and those intuitions in terms of the conversations that we have with you. Now, you also need to work out, do you want a clean exit? Do you want to remain involved? For how long do you want to remain involved and in what capacity? And how much do you need from the business to fund the life that you want? So there's the business reality, and then there's also your personal financial goals, which is why your advisor is really well placed to facilitate some of these conversations. Because once you're clear on the answers to some of these questions, the technical choices start to make a lot more sense. And it's important to understand what's possible given the constraints of your business. So things like the business structure, the debt levels you might be carrying, key person risk, and the tax profile. This is where advisors can help you identify what's realistic and then develop suitable strategies that work within those constraints. Okay. So the key business succession strategies really are as follows. The strategy choice comes down to who do you trust with ownership and control, and what promise are you making to everyone else in the family and the business? So business owners typically have four primary levers that they can pull, and we'll now explore how each of these strategies can work for you, the circumstances that they typically suit, and the typical outcomes that are created from each. Now, as I walk through each of these strategies, you might find yourself drawn to one particular strategy, or you might realize you need a hybrid. So combining these elements from multiple strategies, it's important to realize that's actually quite common. Okay. So the first one, which is pretty common, particularly amongst those that have multiple business owners and partners, is a buy-sell agreement. A buy-sell agreement is a specialized business succession contract that sets out what must happen to an owner's interest if certain trigger events occur. So trigger events typically include death, disability, critical illness, loss of capacity, retirement, or a serious dispute. And these clauses are often paired with insurance policies so that the exiting owner or their estate, if they're passing, receives fair value and the continuing owners can fund the buyout without adversely affecting the business. Okay. Now, these work best when you want continuity among the remaining owners, but you need certainty around the buyout mechanics and how you're going to fund it. So the other big thing to think about when you're constructing a buy-sell agreement is how do you value the business? So in terms of valuation methods, there are three common approaches that we see. Option one is where you agree on a fixed price. Whilst this offers simplicity and certainty and prevents disputes about valuation down the track, it can become outdated pretty quickly. So if the business grows significantly, a fixed price can be unfair to the departed owner's family. And if the business contracts, it's unfair to the remaining owners. So this valuation method only works if you're committed to annual reviews, which can often be unrealistic in our experience. The second option involves agreeing to a formula-based valuation. So this might take the form of an agreed multiple of historical earnings, such as EBITDA or NPAT or gross revenue. You can also use book value with assets less minor liabilities and adjustments that can be made for fair market value. Or you can use a hybrid of these methods where the agreed formula combines earnings and book value. And every business is unique in terms of what valuation method is going to suit different businesses. So whilst these methods will adjust the valuation with business performance, so it's more current, it can incentivize manipulation, such as artificially reducing profits to lower the valuation, and it can lead to disputes over how things like profit are calculated, such as whether the owner's or departing owner's salary should be added back and how discretionary expenses should be treated and allocated. So you need to have very clear terms in the buy-sell agreement. We'll walk through what sort of those terms to watch out for are. So using a multiple of earnings or revenue typically works for professional service businesses or distribution or subscription business models, where the earnings are fairly stable and there are clear market rules of thumb that are entrenched. So each industry, each sector tend to have pretty good rules of thumb that you can use as a bit of a starting place as to how to go about valuing the business and which approach might be best suited for your particular business. Now, using book value tends to work better for smaller or asset and equipment heavy businesses, or holding entities such as investment companies and special purpose vehicles that are set up and have a very specific asset value that is routinely struck in the annual financials. The third option involves obtaining a professional independent valuation at that trigger event. So whilst this often produces the most accurate market value, independent valuations can be quite expensive, time consuming to collate, and it can create further friction between partners if there's disagreement on what the valuation comes back at. So this approach works best for larger, complex businesses where the accuracy matters more than the speed. Okay. So in terms of funding the buy-sell agreement, there are typically three main options for this. It's most common for life and total and permanent disablement insurance policy to be taken out for each key business owner. So when a death or disability event occurs, the policy will pay out directly into the business and allow the surviving business partners to use those proceeds to purchase the shares from the estate of the deceased partner. Whilst this ensures funds are available at that critical time, premiums can be quite expensive and certain partners may be uninsurable. So you need to understand whether this is going to be appropriate for the partners in the business because certain health issues can prevent access to cover. That just is important to be understood. Now, the business itself can fund the buyout from retained earnings or cash reserves. And whilst this avoids the need to pay insurance premiums and go through the underwriting process for each of the owners, it does require quite a high level of discipline to ensure that there are cash reserves that are built up through time for this specific purposes. And our experience is that most businesses don't do this. So, and also if the trigger event occurs when the business might be in trouble, such as a recession or a major customer loss, the funds just might not be there. So there's some pros and cons with this, and funding needs to be carefully thought through. The remaining owners can also borrow the money to buy the departing owner's share. And whilst that avoids the need for potentially expensive insurance policies, it can be very risky to rely on this source of funding because if a departure occurs during a downturn, access to lending might be hard to come by. And also, the remaining owners can be personally liable for the debt and the debt servicing obligations that can be a destabilizing force for the business. So it's not without risk, that approach. That's why it's really important to understand what those risks are and what funding mechanism is going to be most appropriate for you and your business owners' needs. Now, the potential benefits of a buy-sell agreement are pretty clear. It gives all parties a degree of certainty in the sense that the parting owner's family knows that they'll get paid fairly and they won't be stuck as an unwanted partner with the other remaining owners. It also ensures that funds flow quickly, particularly when you've got insurance policies backing up the funding. And it instills discipline as it forces you to think about what the business is worth, how you're going to fund it, and the contingencies that you need to plan for. It also can reveal other important issues that need to be addressed in the planning process. So there are some clear benefits to the buy-sell agreement. Other important considerations to be mindful if you're going down this path is that these agreements need to be reviewed annually to ensure the terms and the funding mechanisms accurately reflect the changing value and ownership structure of the business through time. You also need to make sure that there are clear definitions of all terms in the agreement. This is to reduce the risk of ambiguity that can lead to future litigation. You also need to make sure to consider the tax implications. So just depending on how the agreement is structured, the after-tax outcome for a seller's family can vary quite significantly and requires careful planning with your tax advisors to avoid any unexpected tax liabilities. So it's really important to go through that process and think about whether that's right for you. Internal succession is the second one, and this is really around if there's the option for a family transfer. So this involves ownership and control moving to children or family members, and that can be over time or a set point in time. And this often is while the founder gradually steps back over a period of time. So this approach appeals to those that are looking to keep the business in the family. They want to reward family loyalty and preserve the legacy that you've built in your business. Now, family transfers tend to work better as a multi-phase process, which can take some time. The first phase requires you to build capability through active mentorship that puts them on the path to be a future leader in the business. So this is where your successor is learning about the business alongside you. They're not yet in charge, but they're embedded in operations. They're learning about your key strategic relationships. They're getting a sense of the financial picture of the business, and they're building up their own credibility within the team. The second phase is where your successor is co-managing the business with you. And this might be after a period of 3 years in the initial phase and coincide with maybe up to 6 years. They're making decisions, but you're still involved and you can override if you think you need to. And this is where you start to take that back seat as more of a strategic advisor and a safety net for your successor who becomes an operational leader and starts setting the strategic direction themselves. This phase is really important because it gives you the opportunity to observe their commercial judgment, their risk tolerance, and their resilience before handing over complete control. The third phase after that, for a 3 to 5 year period, involves full ownership transition, where the successor is the primary decision maker and really takes that role of being the business leader. This is where you're still there to support your successor in the major strategic decisions, but you're no longer involved in the operations in a day-to-day sense. And this is also where the business truly becomes theirs. Now, the thing is, without this clear transition, the successor never fully owns the role and makes it their own and earns the respect of the employees. So for retiring owners, this is often the hardest phase because you've been central to the business for so long. Stepping back can feel like a loss of identity or purpose. So it's important to understand that they're pretty natural feelings and emotions to have in this phase. The fourth phase is where you fully exited the business operationally. So you might retain a small stake in the business, you might sit on the advisory board, but you're not involved in the day-to-day business operations. But this phase requires your emotional acceptance that the business is really now theirs to run. And that might mean they adopt a different culture, different strategy, and obtain different results. It also requires clear boundaries on the part of the successor, where they aren't calling you about every crisis after you exit. So it really makes it hard for you to feel like you've made an exit if that's happening. Now, the potential benefits associated with family transfers are obviously that the business remains a family entity with your values that are embedded in it, hopefully. And this matters deeply to many owners. So it's not just a financial asset, it's a living legacy. You also don't tend to experience the disorientation of a complete exit. For many owners, seeing the business continue under family leadership and often maintaining the culture and the client relationships that you've built up over a long period of time can be really fulfilling, and that can be almost more satisfying than maximizing sale proceeds. So you need to understand whether that's a key motivation for you. It also allows you to transition gradually. So shifting from operator to more of an advisor over several years rather than having that sort of sudden exit and the shock associated with that. And depending on the structure, you can really minimize the capital gains through a staged process of gifting and use of family trust and even providing a discount on the share transfers as well. So the tax outcome can be managed a little bit more effectively, typically. But some of the risks and the potential issues to include your successor may not be capable already, and that's just the reality of the situation for some people. Now, one way to prevent this is to test their capability in phase one with real observable metrics. So you need to really quickly get to the bottom of, can they manage projects independently? Do they make sound commercial decisions? Do they have good business acumen? So the successor can also leave. What doesn't work out, you don't have a backup plan. One way to combat this is to build flexibility into the transition process. So this means flexibly structuring the succession strategy to allow the successor either to stay or sell to a willing buyer or bring in capable non-family managers to replace them if required. So you do need a backup plan and some contingencies if the successor does leave. Other important considerations for business owners really come down to internal succession can take time. You need to start this process ideally 7 to 10 years before you plan on fully exiting. And really depending on your retirement needs and the successor's financial capacity, there is flexibility in terms of how you fund the transition. So it can be structured as a combination of a gift, it can be a progressive sale, or it can be an earn out over a number of years. And there's different considerations around all of that. The second or the third option there is internal succession, but through an employee buyout. So how this can work, this is where the existing management team or key employees acquire the business from the current owners, often with a staged funding, and that might include vendor support. So this option works best for owners wanting to reward loyal staff, talented people who you've built the business alongside, rather than handing control to an external buyer. So each manager will often then set up their own acquisition entity, which is typically a trust or another entity to buy the shares or business assets. And the funding mix might include a combination of bank debt, personal investment on their part, or vendor financing where you finance part of it. Or it can be a staged earn-out where they sort of earn through time these shares in the business. And this typically coincides with owners staying on for a transition period to support the key relationships and the business performance. And once you've been paid out, you can either decide to stay on with your successors and discuss with them whether instead you have a clean exit, and what sort of involvement you have in an advisory capacity just needs to be worked through with those people. And the clear benefits of this approach are that the new owners have skin in the game, and this can incentivize them to make the business succeed and can be part of a broader employee retention strategy. It also provides a clear exit path, given you know who's buying and you can ensure the business continuity with proven management capability. But the potential issues to be mindful of are that securing finance can be difficult. Banks might not lend as much to the management team as they would to external strategic buyers. There can also often be a valuation mismatch where management might believe the business is worth less than your asking price. Given they know the operational challenges, this can create some tension in the negotiation process. And it also involves key person risk. So if a primary buyer leaves mid-transaction, the deal can pretty quickly collapse. So it's not without some risk there. Other important considerations to think about is that you need to have a strategy in place to protect your position if the business performance slips after you've partly handed over control, but you still hold the risk through things like security, covenants over debt, or relying on seller finance repayments to be made. So you need to have an asset protection strategy that coincides with this. And employee buyouts tend to work better for mid-market businesses with around that sort of 2 to 20 million in annual revenue as a general rule of thumb. Now, the last one is an external sale. Obviously, you might be able to sell the business to an unrelated third party, such as a competitor or a strategic buyer, private equity, or financial investor. This option is better suited for those looking to maximize the sale proceeds and are comfortable with more of a clean, permanent exit. So a typical external sale process involves a few key stages. You typically need to engage a merger and acquisition advisor, so a specialist to help get the business sale ready. So this might include cleaning up the financial records, introducing some strategies to optimize the efficiency and profitability of the business. The merger and acquisition advisor can also arrange a business valuation and identify some potential buyers and correspond with them. Selected buyers then undertake a thorough due diligence process. And once this is completed, the formal purchase offers are submitted and negotiations commence. So aspects such as the price, the payment structure, what representations are made, whether there's an earn-out, what transition support you're willing to provide, are agreed to as part of this negotiation process. Then we get the likes of Leon and the other lawyers involved to get the legal documentation that covers all of the deal terms that need to be drafted. And we also get the finance side of things confirmed. Before the final stage involves final sign-off and facilitating the transfer of funds and the ownership transfer as well. So it's often the case that founders need to stay on for a period under service, or at least in a consultancy capacity, to support the transition. The key benefits of an external buyer is that they typically pay more than internal transactions because they've got access to more funding and they have that financing lined up, which means you get the proceeds up front. You're not relying on a sort of a staggered or staged buyout. And it also allows typically for a cleaner exit in the case that there's no suitable family or management successor that you've been able to identify. But the potential issues for owners to consider is that many struggle to deal with the emotional challenge of not being able to maintain control and preserve your legacy that you've worked so hard to build. So if you can't accept this reality, then this approach might not be the best strategy. The other thing is that some of your employees can leave when they hear that an external buyer is taking over. The way this is communicated to key staff is obviously very important and needs to be managed very delicately. The other thing is that buyer due diligence can be a quite invasive process and very time consuming. So expect 4 to 8 months of detailed questions, site visits, and documentation review. And there's often a trade-off between speed and value that comes with this approach. So you can sell faster to fewer buyers, but typically at a lower valuation. Or if you're willing to plan for a longer time frame, and if you want to increase competition, that tends to lead to maximized bids. Not always, but that tends to be the case. So in terms of incapacity, it's another big factor that business owners need to plan for. Incapacity planning is about ensuring someone has clear legal authority to run the business if you as an owner cannot, without getting into the scenario where banks are frozen or you're breaching duties or igniting family conflict. And many business owners don't appreciate that control of a business doesn't automatically pass. There are specific levers that determine who can do what when you're incapacitated. So this is where I'll bring Leon in. Leon, can you walk us through the key levers of ownership, control, and decision-making authority that business owners need to understand in the context of incapacity planning for business owners?
Thanks, Dermot. There, it really depends on whether we're looking at a perspective of a top-down or a bottom-up structure. And what I mean by that is when we're talking about companies, ownership often refers to the shares in the company or the units in a unit trust. And with shares in a company come voting power. So that is a bottom-up example of ownership and control through that ownership, being able to vote in meetings and on the larger issues to do with the company that require shareholder approval. Otherwise, if we're talking about a top-down approach, every company needs to have a director or directors. They don't necessarily need to have shares in the company. They can be salary directors, for example. But normally they would have shares in the company. And in that situation, we're talking about a top-down because directors are appointed, they can resign, and they may or may not have actual ownership in the equity of the company. So in terms of ownership, we talk about shares, units, and in a unit trust, for example. In terms of management, we need to appreciate that management can be separate from ownership. It's not always the same thing. So that's when we're talking about directors. We may be talking about partners. If it was a business, it's a partnership. Is there a partnership agreement? And then to take it even a bit further past decision-making authority, we need to consider who benefits from the situation. So ownership, management, and benefit are probably the three things. And benefit may be through dividends to shareholders. It may be through a salary to salary partners or employees of the business. Then we need to think about, so that's in terms of a company. If it's a trust, it could be distributions to beneficiaries. Or if we think a bit larger, sale proceeds. And that's what you were talking about just before in terms of if a business or family business or whatever have you is sold, then who receives that benefit through sale proceeds?
Thanks, Leon. And so the next section, we're just going to delve into some of the family dynamics and start with really the key challenges because this area can create some complexities and some uncertainties, but the complexity of family dynamics can cause even the best laid plans to unravel, is what we've found. And Some of the key challenges that we often see are, particularly for family businesses, where the same person is the owner, the director, the manager, sibling, and a parent. And these roles often have conflicting interests and communication norms. So that needs to be managed delicately. There can also be a case where there are different visions and time horizons that can lead to disharmony. So, for instance, older generations might favour stability, dividends, and legacy, whereas the next gen might push for growth, higher risk strategies, and the reinvestment of earnings within the business. The final thing is that owners can sometimes confuse fairness with equality, and they're two very different things. If you have multiple children where some but not all are involved in the business, it's crucial to adjust your succession plan to account for each of these individual circumstances and their contribution to the business ultimately. So this is because unresolved fairness issues can lead to resentment among siblings, and this can often be prevented with some careful planning and understanding of everyone's unique circumstances. So, Leon, we know that family tensions can become destructive when there's no clear framework for how to manage them. In your experience, how can families effectively navigate these complex family dynamics?
You're right, it is complex and it's a dynamic that changes depending upon the industry, the type of business, the family itself. And uh, the first thing is to always be open and seek out advice. Uh, Advice from professionals, yourself, an accountant, your lawyer, to understand the structure and effect of um, what we've talked about in terms of ownership or control, and be able to first ascertain how that needs to be dealt with. The second thing I would say in terms of navigating the family dynamic is seeking to have open discussion, bringing everybody into the discussion about um, the ultimate goal. Is it that this is a business that's meant to be staying within the family and is going to become a legacy? Or is it something that everyone wants to realize upon a certain event, such as the passing of a parent? So, uh, having them involved in that discussion avoids taking um, certain members of family by surprise, avoiding conflict. Um, and then the other factor would be recording that arrangement. And that can be through a number of different legal documents. One is a buy-sell agreement, as you've talked about, but there's other documents that we'll chat about soon that can see and make sure that certain decision-making powers are with the correct people, that they're able to carry those out at a time that needs to happen, um, and making sure that everything is aligned.
Yeah, I think that's a really key point there, which we'll touch on a little bit later. But that conversation piece, the families that do this most effectively get round the table, are open and honest. And I think a big thing is, use your advisors to be able to facilitate these conversations because they can be daunting and overwhelming and complex.
Mm,
So use us
absolutely.
to help facilitate those conversations, I think is a big key takeaway. So in terms of strategies, we want to give you some tangible strategies to deal with these dynamics. So some of these strategies for owners to consider might include ensuring that each family in the business has a clearly defined role and understands their performance expectations and the decision-making authority within the business. Particularly when it comes to managing contentious issues, it's often worth bringing in a neutral third party. And this could be an independent advisor who can facilitate conversations, can help the family see each other's perspectives, and identify other underlying issues that could lead to future conflict. And in terms of some more strategies, in pursuing fairness, it's important for owners to understand that different asset classes and mechanisms can be employed to achieve this. So, for example, you might give or offer shares in the business for active children that are involved in the business, and you might provide other assets to non-active children and balance it that way. And we can help you with the different planning aspects associated with how to make those decisions. And when it comes to making tough calls, I think framing these decisions as just simply applying agreed rules. So in this way, good governance is really a powerful tool that lets you honour the family and do what's right for the business so that you don't have to choose between the two. So, Leon, when you look at family and private businesses that transition well, what are the key governance habits or structures that are almost always put in place?
They almost always have documentation in place that can be relied upon um, immediately. So, not the handshake agreements. They're fraught with issues. Uh, Having things recorded, and an example that we'll talk about shortly will be a family charter or family constitution, as they're sometimes known. Memorandum of wishes is another name for them. Uh, but also getting into the habit of um, thinking and addressing incapacity and and death, essentially. So whether that's through reviewing your will, looking at powers of attorney and the different types of powers of attorney, the buy-sell agreements, the businesses that transition well have had their ownership uh, considered carefully so that whatever the objective is can pass on to that either next generation or through whatever mechanism it needs to. As soon as there is a lack of consideration and turning your mind to these issues is when something may come up out of the blue and be a surprise, and that can really affect the value of the business. It can affect whatever legacy was thought to be passed on. It can affect goodwill, contracts, all types of things. So the best business persons often seek out that advice and make sure that those things are in place.
Yeah, absolutely. And as you touched on, these are the key documents that make up a comprehensive business succession strategy. And it's important to understand that none of these documents exist in isolation, which Leon touched on, but they combine and they integrate to form a legal and governance scaffolding, really, that holds your succession strategy together. And this is really all to ensure that it actually works when you most need it to. So we'll take a closer look at what each of these documents does, where they fit into the business succession puzzle now. And so starting with the shareholders agreement, the shareholders agreement is a private contract between the shareholders and often the company that governs how the company is run, how decisions are made, and how shares can be owned, used, and transferred. Now, it sits alongside the company constitution and is especially important in family business because it hardwires rules around things like control, exits, and how dividends are paid that are otherwise left to default company law if they're not explicitly stated in a shareholders agreement. And if there's a company driving your wealth and more than one owner, there really must be a shareholders agreement in place. This is a bit of a must if you've got those circumstances. Now, a buy-sell agreement is a specialized business succession contract that sets out what must happen to an owner's interest if certain trigger events occur. And we've touched on this before, but that typically includes death, disability, critical illness, loss of capacity, retirement, or a serious dispute between the owners. And most of these agreements are funded by insurance. So funding is there when you need it, and the business isn't forced to sell assets at a potentially inopportune time. It can also prevent your spouse or estate from having to negotiate with the remaining owners because there it provides a step-by-step process that everyone has already agreed to. So it gives you that certainty and peace of mind. Now, the enduring powers of attorney, which Leon touched on before, whilst a will comes into effect while you die, a power of attorney can enable someone to make decisions on your behalf while you are still alive but incapacitated. And an enduring power of attorney will continue to operate even if you lose mental capacity. So your attorney can make decisions for you in two main areas, financial and legal matters, and also personal matters. And Leon, we've mentioned having both personal and company enduring powers of attorney, but can you talk through why separating those roles is so important in a business succession context?
Yes. So an enduring power of attorney, the key is in the name that it endures through the incapacity. It's not to be confused with a general power of attorney. A general power of attorney you may give someone if you are overseas and you want them to bid on a property, for example. If you become incapacitated, that power of attorney automatically is revoked, but an enduring is not. And it remains in place until such time as you pass or you regained capacity. It's important to understand that when it covers financial and legal matters and then personal matters, they are distinct in themselves. So financial matters and legal matters are uh, as they sound. Uh, your attorney can step into your shoes and bring proceedings in your name or respond to proceedings in your name. They can do things that you could lawfully do. And that includes in relation to finances. Personal is where you live, how you're cared for, and those types of things. But in a business context, we're really focused on the financial and legal matters. In terms of powers of attorney, there is a misunderstanding that comes up quite often that clients think that their personal enduring power of attorney extends to their office or their role as a director of a company, and it doesn't. If you're incapacitated and you have a power of attorney in place, your attorney does not become a director of your company or business. And actually, ordinarily, the company constitution would say that if you're incapacitated, that you become disqualified as a director. And so you drop off. And that becomes its own legal process about having a new director appointed. So that's the first confusion that arises. So we need to look at the particular structure and give thought again to whether it's a bottom-up or top-down structure. And what I mean by that, if it's an enduring power of attorney and we're looking at the shares of the company, if that individual has the predominant voting power, then they would ordinarily be able to carry a vote to appoint new directors. And that may be the attorney themselves or maybe someone else. But that's not always the case. It could be, to give you an example, it could be a husband and wife and children involved in shareholding, and it could be out of 6 shares, 2 to a husband, 2 to a wife, 2 to, 1 each to a child. And they may not have that ability to carry the vote that's necessary. So, and especially if other people are involved, external people are involved in a company. So the personal power of attorney is very important. It deals with someone's complete legal person and personality, their lawful powers and rights. But it may not carry over to the business structure. So then in that instance, what do? We need to consider company powers of attorney, corporate powers of attorney. A company under the law is a legal person. It can sue and respond to proceedings in its own name. It can enter contracts. That is the whole purpose of a company, is it creates an individual between yourself and whatever business that you're doing, industry. So in terms of a corporate power of attorney, it is made by the company, and it's made by the directors at a meeting, and they, if it's a sole director or multiple, they would authorize the company to make a corporate or company power of attorney that says, in the event of a director becoming incapacitated, then the company appoints this person to be able to fill that vacancy or that role. And it can have certain conditions involved, but ultimately it's there as a protection mechanism. Hopefully, it never needs to be used, but it's there as a protection mechanism because um, there can be immediate decisions that need to be made, uh, and those decisions can really affect the longevity of the company.
Yeah, that's a good point. I think also having potentially different individuals that have that personal power of attorney and the business power of attorney and how they interact is really important as well.
Mm.
So, Leon, the extension of that question is what are the key checks and balances that owners can build into their enduring power of attorney documents to reduce the risk of misuse, which is a major concern for a lot of business owners, while still keeping it practical for use with banks and other advisors to work with? How do they sort of balance those two competing objectives?
It's a difficult one because there was always a school of thought of making a power of attorney, um, especially an enduring power of attorney, activated upon a medical practitioner certifying you've lost capacity. And whilst that offers maximum protection, it can also cause delays in that when an event happens, being able to get that document out of a medical practitioner can sometimes be difficult. It also depends on whether they're a specialist or GP, because um, depending upon what it is that you're currently in hospital for, one may not want to sign compared to another consulting um, medical practitioner. So uh, the first question is whether or not that is the method for activation of a power of attorney or whether it's made immediately. We find that uh, many lawyers now and documents that we prepare are often immediate. So that means the moment you sign, the power is granted and able to be used, but we just act protectively over the document. What we do is we have the original in safe custody, and we only release it if someone obtains that letter from a doctor, or that person, if they're unwell or something like that, authorizes the release of certified copies of that document. The banks and other institutions can be quite difficult and create an onus on attorneys where if it is upon a medical practitioner, they sometimes will require them to carry around that other letter from the doctor at all times. And if it's not original, they may want to speak to the doctor and all types of things. So making it immediate while still balancing that protection mechanism by only having a copy at home, not a certified copy that can be used, but knowing where the certified copy can be arranged through your lawyer is often a good balance. And then considering whether the power of attorney itself has conditions or limitations in it. There's certain aspects that, whether it's a self-managed super fund and authority to be able to step into the directorship there, which is permitted only as a special instance for enduring powers of attorney. It's not the norm. Whether that is included, whether there's other limitations that may say you're not to dispose of shares or you're not to use the enduring powers of attorney in a way that is against the wishes of the donor of the power of attorney. All of those things can be included, and it's not unusual to see on occasion. But ultimately, the takeaway is that an attorney must always act in the best interests of the donor. They can't be in conflict transactions between their own desire and that of the donor. They always have to make their own desires second and make sure that the donor of the power of attorney, their wishes and best interests are paramount.
Yeah, I think that's really important. Underlying this is a legal statute that they've actually got to act in the best interests of those who have handed that power over. Now, if we look at the family constitution or family charter, as it's otherwise known as, this is a non-binding governance document that captures the family's mission, its values, high-level rules about how the family interacts with its business, wealth, and each other. And whilst it's not a legal instrument like a contract or a trust deed that we've explored, it does provide a useful framework to guide behavior and decision making across generations. So, Leon, can you unpack for us how the family constitution can underpin the choices made in the legally binding documents so that those documents reflect the family's agreed intent?
It's not unusual that I've had meetings with clients who may be children or business partners or what have you, and they tell me this person's incapacitated or they may have passed, and uh, they have no idea what their who they banked with. They may have no idea why they set things up in a certain way, what their objectives were, their long-term plans, their exit strategy, nothing. It's not unusual for me to have children who come in with a laptop that is password protected, and they say everything that mum or dad had on here is password protected. I can't get into it. Or the mobile that has the second factor authentication. It's all very secure. It's good. It just causes a difficulty in these situations. And we're not in a time that we still get statements that come by mail very often. They all come through email and what have you. So a family constitution is a very good document where, whether it's in relation to a company or whether it's in relation to a trustee role where a company may be a corporate trustee for a family trust, for example, setting out the objectives. This is why this has been established in the way it is. This is why, and this is my vision. This is my intent in setting this up in this way. I've put these things in place. I have considered these aspects. I want you to consider doing these things going forward, which I view as being in the best interests of everyone. The document is not binding, as you've mentioned, because if it's a trustee role or a corporate trustee for a family trust, its protections and its tax advantages come from the inherent discretion. A family trust is a discretionary trust. No one has a fixed interest in the trust. So when you try and start to take away that discretion from a trustee, the law says, well, it's no longer truly a discretionary trust, in which case it doesn't have the asset protection and tax management advantages that would normally carry with that type of structure. So, and that also, when we talk about directorship, a director has a duty under the Corporations Act to always act in the best interests of the company and shareholders, which may sometimes differ from their own. And to try and bind them in a certain way when you may not be able to fully appreciate what situations arise in the future and hold them to something that's rather rigid is a problem. So all in all, what it does is it sets out a pathway. It also helps avoid disputes. When someone's incapacitated or someone may have passed away, it's very easy for people involved to talk about what they shoulda, woulda, coulda. Mum's told me this, but you didn't hear it because it was at the dinner table at Christmas, and well, I didn't hear that, and I don't know anything about it. That type of, well, they could have done this, they should have done that. Well, everyone then comes back to the document that's authored by that person, because they may not be around in a capacity to inform everyone, and it often assists in avoiding disputes, and carries with it also sometimes a sentimental weight that assists with family dynamics.
Yeah, I think that's really important is that these are sort of the family values, the money values, the things that are not captured in the legalese of the other documents.
Mm.
This really helps set the scene and guides your successors and your heirs in terms of what your true intentions are. So with that, As you can appreciate from what we've covered so far, business succession planning can be quite complex and obviously requires careful planning. So, in light of this, these are my top tips. Lean on your advisors. You clearly need the expertise of your accountant, your lawyer, your financial advisor, all working collaboratively to get the best outcomes in terms of tax efficiency, family harmony, and business continuity. Early planning is also really important and allows time to refine your plan, prepare the successes, restructure the entities, tidy up the financials, and manage tax strategically. And finally, consider discussing your wishes with your family to reduce the risk of future disputes. So, regardless of how close your family is, business succession planning is really straightforward because of the emotions that are often involved. And it's likely that your family members will discuss the situation with others, particularly their spouses. So there could be additional opinions that you might have to contend with. So
Mm.
for my clients, I really like to get the family together, particularly in the office around the table here, and have an open discussion. And whilst full transparency may lead to some tension or conflict initially, it also gives everyone a chance to have their say and clarify your intentions. So, Leon, what are your key takeaways?
Often the road taken has already been taken before you. So mine is to learn from others' mistakes, whether it's in the news about certain mining magnates or
Mhm.
media uh, personalities that have had these things aired in the news and are in court all the time. You want to consider those issues of companies, trust structures, the black sheep of the family, the which children or persons may be active or passive in the structure. So learn from others' mistakes and seek out the answers because often it's the case that these things have already happened once before. I always say lock it in before it's urgent. Don't let it be something where it's in the instance that you've gotten on a plane and something's happened. Uh, it's a mess. It could involve things like VCAT and the tribunal here, or NCAT or QCAT, whichever state you may be in. Don't let it get to that point because that's often when it's most pressing, where mistakes do happen and where the outcome may be not what you wanted or envisaged. And whilst we always focus on passing and passing wealth over to the next generation, it's very important to plan for incapacity, not just death. Incapacity can be substantial. It doesn't need to be after an accident. It could be a degenerative disease, for example. And so, considering what happens in those circumstances, those are my three top tips.
Thanks, Leon. And just rounding this out, by integrating legal expertise with comprehensive financial planning, we're able to deliver more holistic, tailored solutions that are reviewed more regularly, tend to lead to better outcomes, and give our clients the peace of mind that their legacy is protected. So I'd urge everyone on the call and those watching after to please reach out to your advisor to start that discussion about your business succession planning intentions. And after that, we can then introduce you to Leon or one of his colleagues to fine tune the strategy and provide you with a quote for putting these really crucially important documents in place. So, with that, we'll now take a few questions from the audience. And whilst we're waiting for these questions to come through, one that we often get is if the business is owned through a family trust, who actually controls it after they die, whether it be the shares, the trustee company, or the appointor. Leon, have you got some thoughts on that one?
That's an interesting one because often what we have to do is go straight back to the trust deed. Who is appointed as the trustee of a family trust? Is it a company or is it an individual? Um, if it is a company and the person who has passed has the shareholding or directorship, we need to consider exactly what we've talked about. What shareholding is there? Is it able to compel votes? If it's the directorship and they're the last director, the executor stepping into um, their shoes in terms of that role. If it's an individual, uh, again, the executor stepping into their shoes. So the trustee, we're often looking at day-to-day decisions in terms of what decisions are made in terms of um, investment, distributions, tax returns, all of those types of things. But we can't ignore the role of appointor. The appointor is very important. The appointor, there's one for every trust, and their role is to remove and replace the trustee um, without any reason. So they don't need a reason to be able to do it. It could be that the trustee is incapacitated, they're acting badly, something has happened where they've passed and there's no succession in the deed or document there. That's their role. So looking at that and considering how that comes into play in terms of the larger structure and intent. And I will normally work with clients to restricting who can be appointed as the appointor. You don't want a trustee that says, for example, I appoint my accountant as the appointer of my family trust, who you may trust implicitly. But in the event that they pass, it becomes the executor of their estate, because that could be anyone. It could be another professional. It could be their wife or husband, and you don't have a relationship with them. And suddenly they're the appointer of your family trust, able to remove and replace the trustee. So we look at those type of aspects in terms of keeping them in the bloodline. It's often the case that family trusts are intended for the bloodline, and that's why our American counterparts call them bloodline trusts.
Mm. Yeah, it's really important because a lot of our clients have their family businesses owned through a trust structure, or at least a trust is involved in some way. One of the other questions that's come through is, when should I actually start my succession planning and how long does a good transition usually take? So my answer to this would be earlier than you think. So if you're planning an exit with an external buyer, you really need to budget for that 3 to 5 year time frame, and 7 to 10 years if you're looking for a more of a smooth transition that involves family or management succession. So to get all of these ducks lined up, and restructuring of the business and the financials can take a lot longer than you think. So the longer the lead time that you've got, the more options you have at your disposal, and typically the better the outcome as well. So beyond that, Leon, are there any other questions that you thought we should address?
No, one observation that I think that at Act Wealth we have something that's very special in terms of we have what is a very collaborative um, ability to assist our clients. It's great being able to have meetings with clients where you have joined Dermot and the other advisors, so that clients aren't having to um, take information away which may be interpreted differently to an external advisor and back again. Things get lost in translation. So I encourage clients to seek out your advice, to seek out my advice. And of course, we work very closely together in ensuring that everything lines up the way it should.
Yeah, well said. Good point. And we see ourselves as that conductor of the orchestra, as you mentioned, and making sure that we're actually managing all the different projects and responsibilities and the specialization of different people that we need to get around the table. And we know enough about the different areas to be dangerous, as I say, but I think we know what questions to ask, and we know the clients intimately as well and what's important to them. So reach out to your advisor to start that conversation if you haven't already. So thank you, Leon, for sharing your insights, and thank you to all who joined us today. We hope that you enjoyed the webinar. And if you have any other further questions, please do not hesitate to contact us or your advisor to discuss further. Until then, bye for now.